Yes. In a land agreement whereby there's a buyer and seller, who should draft? Who does the law says he should draft between the buyer and the seller? Now, before we answer this question, let's first of all look at the gauging value. If there is no agreement, if an agreement is not drawn, who will run at loss between the seller and buyer? Who will be taking undue advantage of if there's no, there's no agreement? That is, if a deed of assignment, a deed of lease, whatever the deed, if it's not drafted, who will run at loss? Now, your guess is as good as mine, which is if agreement is not drawn, it means the intending buyer will be at loss. Why? Because the seller can just go away, swing away with his money, and there's no proof that transaction took place. So that is why, in the eyes of the law, is the the buyer that should drafts. Seriously, because if the transaction does not go well, is the buyer that will run at loss. So that is why it's the duty of the buyer to always bring a lawyer to draft. Yes, as a buyer, once you have done, the legal search by involving, because you have to involve a lawyer to do the legal search, employ a lawyer to do a legal search. If you fail to do a legal search and that property is bad, I mean that property is bad, it has bad title, it's not good, it will it will be at your own peril. But if you engage a lawyer, that won't happen. So make sure at the contract stage, engage a lawyer to do a proper legal search for you. That aside, now once you find out the property is sound, it's not encumbered, it's not government property, it's not family property, it's not property likely to be acquired by the government, it's not property likely to be used for public purpose and the rest. The next thing you should do is, as a buyer, go to the lawyer. Give the particulars of the transaction, seller, how much you pay, location of the property, everything about the land. Give to a lawyer, your own lawyer, and allow your lawyer to prepare the agreement. Now, here is it. If the seller tells you, "Oh, I have my lawyer, allow my lawyer to draft it for you," say no, refuse. You know why? Because the seller may want to protect his own interests as against your interest. Ordinarily, it's your interest that should be protected as the buyer. So that is why make sure you are the one drafting as the buyer. Once you draft, don't sign. You see, don't sign as the buyer. Give it to the lawyer and to the seller. Let the seller sign. After the seller signed, then you cannot sign as the buyer. Once you are comfortable, you are fully satisfied that, oh, the seller signed very well, you will sign, then hand the paper to your lawyer to sign. Don't forget, in Nigeria now, writing what's it called? Writing land documents, is purely 10% of the principal sum. 10% of the principal sum. You see, anything different from that is null and void. Do you want to lose your land just because of 10%? Think about it. Or do you want to spend 16 years, 20 years in court doing land case because of 10% refuse to pay a lawyer?